Dear students, I welcome you to yet another lecture on corporate law. The topic of discussion for today's lecture is liability for misstatement in the prospectus. If the prospectus contains a misleading statement, the liability of the company, the directors, the promoters and others who authorize the issue can be classified into two kinds. That is, number one, civil liability, and number two, criminal liability. Civil liability can further be classified into three groups. 1. Damages for deceit. 2. Rescission of contract under the Indian Contract Act. Number 3. Compensation under the Companies Act under Section 35. Dear students, we shall study each of these liabilities or remedies available under the various laws in detail. The first is damages for deceit. In order to succeed in an action for the tort of deceit, fraud has to be proved. Any person who, on the basis of a fraudulent statement in the prospectus, has been induced to invest money in a company can sue the person responsible for issuing it and claim damages. In order to prove a fraud, it has to be proved that the false representation was made by the company A. knowingly, or B. without belief in its truth, or C. recklessly, whether it be true or false. Thus, any reckless and careless statement made in the prospectus without ascertaining its veracity renders the company liable for fraud. For the purposes of fixing liability for misstatements in the prospectus, the meaning of untrue statement is wide in its ambit. It includes any statement which is misleading in the form and the context in which it is included. Also, if any matter is omitted from a prospectus with the intention to mislead, the prospectus shall be deemed in respect of such omission to be a prospectus in which an untrue statement is including. Regarding liability for fraudulent misstatements in the prospectus, certain principles may be taken into consideration. A. Intentional falsehood. Firstly, the aggrieved party has to prove that the person making the suggestion knew that what he is stating in the prospectus is not true, or did not believe it to be true, or it is an active concealment of some material fact. However, if a person making the statement honestly believes it to be true, he is not guilty of fraud even if the statement is not true. This principle has been enunciated by the House of Lords in Derry versus Peake. The facts of the case are: a special act of the Parliament incorporating a tramway company provided that carriages might be moved by animal power and with the consent of the Board of Trade by steam power. The directors issued a prospectus stating that by their special act, the company had the right to use steam power instead of horses, and this would bring about considerable saving. No reference was made to the Board of Trade, who eventually refused their consent. Consequently, the company had to be wound up. The plaintiff, having taken shares on the faith of the statement, brought an action for deceit against the directors. The court held that directors were not liable, for they honestly believed that once the Act of Parliament had authorized the use of steam, the consent of the Board of Trade was almost certain. The second element is representation must relate to some facts. The false representation must relate to some existing facts which are material to the contract of purchasing shares. The case of Edgington versus Fitzmaurice illustrates this point further. In this case, the directors of a company issued a prospectus inviting subscriptions for debentures. They stated in the prospectus that the object of issue of debentures was to complete alterations in the building of the company and to purchase horses and vans to expand the trade of the company. It was found that the real object of the loan was to enable the directors to pay off pressing liabilities. The plaintiff took debentures relying upon the statement in the prospectus. The company became insolvent. Therefore, the plaintiff sued the directors for fraud. It was held that the directors were liable for deceit. A statement of a man's intention may be a statement of fact. Lord Justice Bowen said, and I quote, "This is an action for deceit in which the plaintiff complains that he was induced to take certain debentures by the misrepresentations of the defendants and that he sustained damage thereby. In order to sustain his action, he must first prove that there was a statement as to facts which was false, and secondly, that it was false to the knowledge of the defendants, or that they made it not caring whether it was true or false. For it is immaterial whether they made the statement knowing it to be untrue or recklessly without caring whether it was true or not, because to make a statement recklessly for the purposes of influencing another person is dishonest. It is also clear that it is wholly immaterial with what object the lie is told. But lastly, when you have proved that the statement was false, you must further show that the plaintiff has acted upon it and has sustained damage by so doing. You must show that the statement was either the sole cause of the plaintiff's act or materially contributed to his so acting." Unquote. Further, he said, "There must be a misstatement of an existing fact, but the state of a man's mind is as much a fact as the state of his digestion. And the real question is, what was the state of the plaintiff's mind? And if his mind was disturbed by the misstatement of the defendants, and such disturbance was in part the cause of what he did, the mere fact of his also making a mistake himself could make no difference. It resolves itself into a mere question of fact." Thirdly, in order to succeed in an action for fraud in a prospectus, it is necessary that the plaintiff should have taken the shares or debentures directly from the company by allotment and not from any intermediary agency or open market. This, in other words, means that only allottees can have the remedy against the directors. This rule was for the first time laid down in Peaks v. Gurney. In this case, the defendant issued a prospectus containing a fraudulent statement on behalf of the company. The plaintiff received a copy of it but did not take any shares originally from the company. A few months after the allotment, he purchased 2,000 shares on the stock exchange. His action for deceit against the directors failed because he was not the initial allottee acting on the statement contained in the prospectus. The court held that liability to allottees does not follow the shares in the hands of subsequent transferees. It was held that the function of the prospectus had exhausted with the allotment of shares or debentures by the company. Fourthly, in the absence of a contractual relationship, a person who makes a statement owes a duty of care to anyone whom he knows or has reasonable grounds for expecting will rely on his statement. If he fails in that duty of care and the party which is misled suffers loss, he shall be liable for negligence. Dear students, we shall now try and understand how to fix the quantum of damages. In Twycross versus Grant, the plaintiff had bought shares in a company promoted by the defendant. The prospectus was fraudulent, having failed to mention certain contracts which made the shares valueless. It was held that the shares being worthless, the plaintiff was entitled to have his price repaid. Chief Justice Cockburn said, and I quote, "If a man buys a horse as a racehorse on the false representation that it has won some great race, while in reality it is a horse of very inferior speed, and he pays 10 or 20 times as much as the horse is worth, and after the buyer has got the animal home, it dies of some latent disease inherent in its system at the time he bought it, he may claim the entire price he gave. The horse was, by reason of the latent mischief, worthless when he bought. But if he catches some disease and dies, the buyer cannot claim the entire value of the horse, which he is no longer in a condition to restore, but only the difference between the price he gave and the real value at the time he bought." Unquote. Dear students, we now study the civil liability under Section 35 of the Companies Act 2013. The decision of the House of Lords in Derry versus Peake exposed the inadequacy of the remedy of damages for deceit. It was realized that this remedy could not protect the interest of investors when the misstatement in the prospectus was made by the directors innocently in good faith. A common investor is hardly concerned whether the misstatement in the prospectus was a deliberate falsehood or made by the directors in good faith innocently. His concern is that he should be compensated for the loss caused to him due to the misrepresentation. It is for this reason that within a year of the decision in Derry versus Peake, an act called the Directors' Liability Act 1890 was passed in England, whereby the directors were made liable for misstatement in the prospectus, although they might have believed that the statement was substantially true. Subsequently, this provision was incorporated in Section 43 of the Companies Act 1948, and a corresponding provision to this effect is to be found in Section 35 of the Companies Act 2013 in India. The section provides that the directors, promoters, and every other person who is authorized to issue the prospectus of a company shall be liable to pay compensation to an investor for any loss sustained by him due to an untrue statement in the prospectus. The conditions for the applicability of Section 35 are: number 1, a person has subscribed for shares of a company. Number 2, in doing so, he has relied on any statement in the prospectus which is misleading. Alternately, omission of any matter in the prospectus which tends to mislead shall also attract liability under Section 35 of the Companies Act 2013. Number 3, as a consequence, he has sustained any loss or damage. Dear students, now we try and understand who can be held liable under Section 35 for misstatements in the prospectus. According to Section 35 of the Companies Act 2013, the persons who are liable to pay compensation to a person who has sustained loss or damage because of a misstatement in the prospectus are: number 1, a person who is the director of the company at the time of the issue of the prospectus. Number 2, a person who has authorized himself to be named and is named in the prospectus as a director of the company, or has agreed to become such director either immediately or after an interval of time. Number 3, a person who is a promoter of the company. Number 4, a person who has authorized the issue of the prospectus. Number 5, a person who is an expert referred to in subsection 5 of section 26. The liability of the directors or promoters, as the case may be, is joint and several, and they may recover contribution from others who are guilty of misrepresentation. In Greenwood versus Leather Shod Wheel Company, a wheel manufacturing company issued a prospectus in which it was stated that the orders had already been received from the House of Commons to supply wheels for the trolleys in use in the House. In fact, not a single order was obtained except for trial and by way of experiment. The court held that the prospectus contained an untrue statement and the directors were held liable. Dear students, we shall now try and understand the defences that are available under Section 35. Section 35, Clause 2 of the Companies Act 2013 provides certain defences that shall be available to a director or any person for liability for misstatement in the prospectus. It states that no person shall be held liable under Section 35 if he proves a. that having consented to become a director of the company, he withdrew his consent before the issue of the prospectus, and that it was issued without his authority or consent. B. That the prospectus was issued without his knowledge or consent, and that on becoming aware of its issue, he forthwith gave a reasonable public notice that it was issued without his knowledge or consent. Dear students, we shall now discuss another remedy, which is rescission of the contract under the Indian Contract Act. The person who purchased shares on the basis of the prospectus containing misstatements can rescind the contract, which means that he can cancel the contract. He is eligible for rescission whether the statement is made intentionally or unintentionally. He has to surrender his shares to the company. Then his name will be removed from the register of the members. The money paid by him will be refunded by the company. There are certain conditions that have to be satisfied for claiming rescission. These are: number 1, there must be an untrue statement or misrepresentation. If a company provides for misleading statement or omits any matter which misleads, then this shall constitute as an untrue statement or misstatement. It is not necessary that there must be a false misrepresentation. Mere suppression of material facts renders the whole prospectus fraudulent. In R versus Keisland, the business prospectus indicated that the dividends had been paid on a regular basis, giving the appearance that the company was profitable, whereas the fact was that the company had been losing money for several years and dividends could only be paid out of wartime earnings. The omission of this information was deemed a misrepresentation. The second important thing to remember is that the misstatement must be material to the contract of issuing shares. It should not be a mere expression. Thirdly, the shareholders must have relied on the untrue statement. Fourthly, the statement must have induced the shareholder to purchase the shares. Fifthly, the shareholder must apply for rescission within a reasonable time and before the liquidation of the company. Sixthly, the shareholder should not have affirmed the contract for purchase of shares. In Aronson versus Smith, the court asked whether a misrepresentation in a prospectus was corrected by a circular issued after shares had been allotted to the investors who had relied on the prospectus. It was held that it was not, and that what would have been required was a clear statement in the circular calling attention to the fact that there was a serious error in the prospectus. Dear students, we shall now try and understand the limitations that are there on the right to rescind for fraud or misrepresentation. A contract induced by misrepresentation can be rescinded by the aggrieved subscribers. However, such a contract shall be valid until it is rescinded or cancelled. But the right to rescind is not unlimited. It shall be lost in the following situations. By affirmation. If the allottee, having knowledge of the misrepresentation, affirms the contract and does not rescind it, he would lose the right to rescind. The affirmation may either be express or implied. Thus, whereon discovering the misrepresentation, the subscriber, instead of rescinding the contract, sells his shares or attends meeting of the company or receives dividend or pays call, he shall be deemed to have affirmed the contract, thereby losing his right to rescind. Second is undue delay. Unreasonable delay in exercising the right to rescind the contract on the basis of misstatement shall adversely affect the right of the subscriber. In re Christine Weil Estates Limited, the plaintiff came to know about misrepresentation in the prospectus in July, but he moved an application to have his name removed from the company's register in December. It was held that the delay of 5 months disentitled him from exercising his right to rescind. Third is on commencement of winding up. The right to rescission is lost on the commencement of winding up of the company, and the shareholders shall not be permitted to escape liability. Dear students, this is all with regard to civil liability. Now we shall try to understand the criminal liability for misrepresentation as provided in Section 34 of the Companies Act 2013. Apart from the civil liability for misrepresentation in the prospectus, the company law also provides for criminal liability under Section 34 of the Companies Act 2013. The section says that where the prospectus includes any untrue statement, every person who has authorized the issue of the prospectus shall be punished under Section 447 of the Act, which provides punishment for fraud. Any person found guilty of fraud may be punished with A. Imprisonment for a term which may not be less than 6 months but which may extend to 10 years, and B. Fine which shall not be less than the amount involved in the fraud but which may extend to 3 times the amount involved in the fraud. C. Both imprisonment and fine. However, he shall not be criminally liable if he proves that the statement was immaterial or that he had a reasonable ground to believe that it was true. Dear students, with this we wrap up today's lecture on liability for misstatements in the prospectus. In today's lecture, we try to understand the civil liability as well as the criminal liability for misstatements in the prospectus. Hope you enjoyed today's lecture. Stay blessed.